John Wertz here. I'm with Vince Santini, and he's running for the new 457th District Court. And it's November 20th. Thanks for coming in, Vince. Appreciate it.
Thank you.
Answering the questionnaire and coming in to interview. With me is Larry Rogers, Dale Fessenden, Bob Bagley, Dennis Smith, Dennis Tibbs, and Pat Tibbs. I had a friend, Dennis Smith. So Vince, as we discussed, why don't you get us kicked off here, up to a 5-minute opening, and then we'll go around the table with questions.
Thank you. And once again, thank you all so much for what you do in the vetting process. It's very important. The Tea Party is a very important group in Montgomery County for what you all stand for and the time that you take. And your endorsement means a lot. It means a lot to the county. And y'all's choice, you could choose the next judge of Montgomery County. And that's very powerful and it's very serious, and I take it seriously. I hope you all saw that from the questionnaire. I spent some time on there. Could have spent a lot more time on there because what the questions you could really write a thesis on these things. But
you did pretty good.
I wanted to thank you. I wanted to leave some room for discussion. But look, I mean, Montgomery County is the greatest place to live. It really is, and the United States is the leader of the world. In Texas, it's the heart of our country, and Montgomery County is the heart of Texas. And so I've lived here for about 16 years. When I went to law school, my parents were living in Bentwater, and now my whole family is in Montgomery County. And so I have 23 nieces and nephews. I love this county. I want to give back, and that's why I spent my career here serving the people of Montgomery County. I was a district court chief prosecutor here, handling the most serious crimes, and a special victims unit prosecutor. And I helped children under the age of 10 who were physically and sexually abused. I've been in the limelight before. I've learned how to talk to the media. I've had some bumps in the road, not getting my message across, but you learn. And being in the spotlight for almost a decade in our county, I have not gotten in trouble. I've represented our county and our interests very well. And I spent my time giving back to the community as much as I can. And so when I think about running for this position, I think there's qualified people, but you have to take, and I mentioned this in my answer, you have to take the qualifications. You have to look at what the job duties are of the court first and foremost. And then you see, are you qualified to match those job duties? So the 457th, it's going to be presiding over trials, primarily civil, right? That's what the Board of Judges are. And I answered this, I'm not trying to change the designation. Wherever the Board of Judges needs, I'm a dynamic attorney, I can go and do that. And I've done that my whole career. Whenever there was something new that needed, a new arson prosecutor, they sent me there. SVU, the new laws passed, they send me to prosecute these things. So presiding over trials. You have to rule on issues of law and the constitutional issues. This court was created for one reason, case management. Okay? But it also rules on criminal matters. We preside over 2 grand juries, you do subpoenas, you set bonds, and then you have to work an on-call shift where you review search warrants. These are huge constitutional issues that conservatives care about. All right? I have experience in every single one of these areas. For trial, I was the leading trial attorney, trial advocate in the nation. South Texas College of Law has 133 national titles. I was their #1 guy. The Tournament of Champions, which is the #1 tournament, the 16 best schools in the nation, I was tied for best speaker there. I was champion. I tried about 150 mock trials before graduating law school. So I was already an expert in the rules of evidence before I tried my first case here. I participated in about 75 trials. And it's important because when you think of the civil versus criminal, well, if you think about OJ, he was liable under wrongful death, and he was not convicted of murder. We saw the evidence he should have been, but different standards. So criminal law handles very similar causes of action, just on a higher degree, higher due process, higher burden of proof. It's unanimous verdict versus civil law is not unanimous verdict. So we're dealing with the constitutional issues, confrontation, right to an attorney, the search and seizure issues that we care about. All right, a ruling on issues of law. I'm an expert in rules of evidence, which is the very same book used in criminal and civil law. Not to mention, I'm a full-time civil litigator. That's what I do all day, every day. All right, so I take cases from the beginning, through pre-suit demand, through petitions, discovery, motions, all the way through. That's what I do. This is what this court will be working on. Docket management. We care about efficiency, judicial efficiency. I was in charge of 2 separate district court dockets in Montgomery County, the 435th and the 359th. Month after month, I disposed of more cases than came in. My docket shrunk. When I was the chief prosecutor of County Court at Law Number 1, we couldn't buy a trial. My dockets were really small. That's what we need. You wake up early, and I have a plan to do this. We can talk about that later. But I have a plan to move the court very successfully, very similar to what Judge Bays does. Very similar plan of action. And then for the other ones, the other 2 issues, presiding over the grand jury and doing search warrants, working on call. I've done that my entire career. I've reviewed thousands of search warrants. I've presented in a lot of grand juries. I got what it takes, I think, and other people believe in me. I've worked in 16 out of the 17 courts in Montgomery County. So 16 elected judges. I don't mean the municipal courts, the city courts that aren't elected. I mean of the elected officials. I've worked 16 out of the 17. So I've learned from some of the best, and we got some pretty good judges in our county, and partially because of y'all's vetting process. And so I'm going to open it up, and if you like, I'm a lawyer, I like to talk. So, but I'm ready. I think I'm going to cross my fingers.
All right, well, sounds good. Thank you for that overview.
Sure.
Won't we continue on? You said you're going to work the process similar to Judge Bays, and that you would explain that. Why don't you go ahead and take
Sure.
that opportunity?
So the one thing we need to understand with a civil court, it's very easy to pass the buck. Very easy because so much happens between lawyers outside of a courtroom. The judge gets involved, and I'm not saying the judge doesn't do anything. Judges are very busy in civil law. But criminal law, you're in dockets every day. You're dealing with your case every day. The attorneys are in court every day. All right? Civil law, the judge sets up, in some courts they don't. Some courts they do. I would. But you set up a docket control order immediately after an answer is filed. A petition's filed, and then hopefully within 30 days an answer's filed by the defense. All right? Immediately, as a judge, I would do a docket control order, a scheduling order, laying out all the deadlines that are to be met immediately. Because what happens in some courts is, well, okay, we'll see what happens, we'll see what they file, what they don't, and there months go by without a trial date even set. Because civil law, once the trial date's set, you kind of work backwards from there. You say, okay, 30 days before the trial is discovery deadline, all right? All things must be done, all depositions must be taken from there. You work back from there 60 days before trial, and you go back from your motions and everything, okay? So hard and fast dates, number one. Number two, you get, and this is what Judge Bays was number one, was you need a professional staff. Because she's got a briefing attorney. She does tax docket as well, so she has 2 coordinators. We would need 1 for this court, and if they just keep it civil, you're not going to need 2 coordinators. But you will need a court administrator that handles the day-to-day things outside and inside of the office. You need more paper, you need to take calls. So you get a really professional staff that are going to work hard. Hard and fast dates with a docket control order. You have a motions docket, you can have submission docket, and a hearings. Yeah, there's my time. That disposes of a lot of things, all right? Trials are important in civil law. People say that only 1% of cases go to trial. Well, it's the trial dates that keep the cases moving. And part of the reason why they're so low of trials is because there's only 52 weeks out of the year. If you say probably 50, I'm going to try and do 51 weeks out of the year trial. 51 weeks out of the year out of 1,400 cases, that's where that percentage comes from. But unless you have those hard and fast dates, unless you're willing to go to trial, the cases are not going to move. I will have status hearings where if the cases aren't moving, we will call them up to court and do it. You have to bring the attorneys into court. That's a difference. You can't, it's so easy to pass the buck in civil law because all the discovery happens between the lawyers outside of court. So as a judge, you have to rein them in, bring them to court, have them answer to your docket. And if there's a valid reason, okay, well, give me a valid reason. You want to do what's right. The first rule in the rule of evidence is to make sure that it's for truth and justice, right? First thing in our Constitution, to establish justice. We want to see that happen, do the right thing, but you have to hold these attorneys' feet to their fire because they are busy. Unless you're bringing them into the courtroom, stuff's not going to move, and that's what Judge Bates does.
Okay, couple of things. You're doing civil now,
Yes, sir.
so you're not with the county anymore.
No, sir, I'm not.
How long have you been private practice?
I've been in private practice since my last day at the DA's office was Friday the 13th, July 13th, 2018, and then I didn't take any time off. I haven't had a vacation in 2 years. Monday, this July 16th. So since July 16th, 2018, I've been full-time civil litigator. I'm the senior litigation attorney at my law firm.
All right. I'm having a hard time understanding, you just mentioned that the 457th will be presiding over the 2 grand juries.
Yes, sir.
And handling civil cases.
Yes, sir.
But in your one of the questions, you answered that it's primary of civil court, but it does handle major criminal matters.
Correct.
Could you explain that a little bit?
Yes, sir. So in court, inside the courtroom, it's going to handle primarily civil cases. It's set up that way by the Board of Judges. I'm not trying to change that. That's fine. But every single district court in Montgomery County, the 418th, Tracy Gilbert, who's a family law judge, 410th, Judge Robin, 284th, Judge Bays, civil court, you still are on call. You work 1 week out of the month, or however many, there's going to be 8 judges now, so 1 week out of 2 months now, that's nice. You are on call to handle and review search warrants after hours, so 24/7. It can happen during court too, so if a murder happens during the day and you're in docket, you'll see detectives come in or investigators come in the middle of your docket, and they'll stand in there with a search warrant. And you have to review that because you want to make sure the government's not just going to people's houses. So you want to make sure the elements are there. You want to make sure that they're following procedure. So you're on call, and that can happen 2, 3 in the morning. It's major things. Also, outside of the courtroom, Mr. Rogers, is the district court judges, even civil judges, preside over 2 grand juries. So Tuesdays and Thursdays, there's a separate grand jury, so they meet once a week. And so they do voir dire, we would pick the grand jurors, we would sign subpoenas, we would set bonds. So we hear about the bond debacle in Harris County, where violent criminals are getting out on PR bonds and they're reoffending. These are serious matters that actually the civil court, district court judges will handle in our county. And so it's very important. It actually affects our community. You wouldn't realize that. So that's what I mean when I mean criminal matters.
Yeah. Okay. Real quick. So you have your own private practice, or are you with a firm?
I'm with a firm. I work for the Voss Law Firm, just in the Woodlands, just on the feeder road going south, past the mall, past the Olive Garden. It's right there.
Okay. So you would have to resign and not have
Yes,
a private practice, obviously.
Yes, sir.
Okay.
I will. Yes, sir.
Okay.
Okay, you mentioned in your introduction that you're an expert on, and you've mentioned several times in your questionnaire, you're an expert on this, an expert on that. Maybe I didn't put 1 and 1 together and get 2, but what qualifies you as an expert? All right, did you take a test and get 100%? Did you get a certification from some organization? What qualifies you as an expert?
I like your question, and so I will turn to the Texas Rules of Evidence to answer that. So the 700s are what you deal with experts, okay? How do you qualify an expert, and it kind of mirrors the federal rules. And so to be an expert, it can be based on education, training, experience, knowledge in a particular area. And so I don't just mean I'm a civil expert. I don't want to just grandiose paint it. What I mean is trial. So when you think about trial, there's specific rules that you have to follow in the middle of trial. So, and it happens like this. Someone wants to enter a piece of evidence. As the judge, you don't know the facts of the case. You may know a little bit from the motions that are filed previously. So by the time trial comes, you're going to probably get past a motion for summary judgment, a motion to strike experts. You're going to know more in a civil court than you are in a criminal court up to that point. But during trial, there are so many ways a case can go south and get flipped on an appeal. Whether it's picking a jury, not letting the right questions be asked, whether it's admitting a piece of evidence that you should not admit, that can be flipped, letting them go down a line of questioning that shouldn't be asked, whether it's striking or allowing certain witnesses to testify when they shouldn't or should. The jury charge, if you're allowing certain instructions in the jury charge, there are so many ways. If you don't know about trial, a case can go south and get flipped. Every one of these areas I have a lot of experience in, having participated in the highest. I've tried capital murder cases, I've tried life without parole capital punishment cases, the very highest standards, and I have not gotten flipped on appeal. So it starts from the very beginning all the way through. You have to when you're presenting a case and when you're prepping a case, you have to start from the beginning and look towards the end. All right, how would this play out in trial? And that's what I've done. So jury selection, objections, evidence, examination of witnesses, closing arguments, jury instructions, punishment, expert witnesses. These are all very, very intense areas that I've handled throughout
So
my time.
what are the qualifications for an expert?
Qualifications for
In
a
any
witness?
particular area?
Sure. So
Can you give one example?
let's say for an engineer, right? That's probably a common one that we're going to see in civil law, right? Whether it be a car accident case or for one of the cases I work on, an insurance case for a roof. All right? This is what's known as a soft science. It's not going to be a hard science like a doctor where you're going to have studies. There's different tests. So for the soft sciences, you would look at what did they review? Are they reviewing documents that are commonly relied upon by other experts in that field? Are they applying those principles to the facts in this case? All right? Are they going to the scene? What data are they relying upon? That kind of goes to the principles. Are they qualified? You will listen to what their qualifications are, their schooling. Do they have a degree? Are they certified in certain areas? The great thing about this is you look at the area, the designation first. I'm going to designate this person to talk about causation, what caused damage to this roof. All right? And then the rules allow that. There's no one mutually exclusive way to become an expert. You could be, I spent 33 years for the Rickowie Institute, the Roofing Institute, investigating hail claims, and this is the hail case. And I'm trying to determine whether hail was caused by May 21st, 2017 storm or not. So it starts with a designation, then you look at their experience, you look at their education, you look at their work history, you look at their investigation in this case, so are they qualified? Then what they did in this case to render an opinion, and is that opinion valid? That's what the judge has to be the gatekeeper of, to not allow junk science or junk testimony to prejudice the jury.
Okay, Bob?
You made a comment earlier, and it was slight, but I still picked up on it. It said, if they keep this court a civil court. The whole reason for starting this court was for it to be nothing but a civil court. So why would you make the comment that if they keep it?
The reason why I said that is because I don't know the future. And so we've seen where the 410th was general jurisdiction and they switched it primarily to civil. And also I said if because Judge Bays frankly is doing a very good job. She inherited 2,400 cases, and that when the court was created, the 457th was created, it was with that 2,400 cases in mind. In 8 months, she's reduced the docket by 25% down to 1,800 cases. So when I say if, it's just because I don't know the future. I'm not running to change it. I don't want to change it. I don't care if they change it. That's up to them. But you have to leave that possibility open because it's happened in the past. So we have to look at like any other feasibility study. You look at 5-year, 10-year, 20-year. So you need to elect a judge that, you know, hopefully you want the judge in there for a couple terms, or if they're doing a good job, if not, then come and get somebody else in. But if the second term comes by and everything changes and the dockets are leveled out and they need to make it general, then they might do that. I just don't know.
If the dockets level out and there's no need, then they can dissolve the court, right?
They could.
That's not feasible.
Right.
The feasibility of us changing and things getting better are not that good.
Right.
You said you had a year and 4 months experience, or you didn't say that, but when you talked about getting out from the DA and starting with this law firm, that gives you a year and 4 months in civil litigation.
Yep.
Wasn't there a minimum requirement to take the job when you applied for the governor for the appointment for this position?
Not that I'm aware of. That wasn't in any of the questionnaires. I think what you're referring to is what Mr. Kasperzak put as a federal appointee. That's what he's referring to for a federal appointee.
No, I was just looking at information. I didn't get it from him, so
I don't know. Not in any of the questionnaires not that I saw. And by the way, I wasn't going to do that. I was campaigning here for the voters, but you know, they said it's opened up, you might as well go do it, and I applied after I was campaigning already.
Well,
so I don't know of anything.
You wasn't going to do it, but you did it, so you can't blame it on whatever. You applied, so you wanted the job, and so you applied for it.
I do want the job.
Okay.
I want the job. I would love to get this job.
Is it an increase in pay for you or a decrease?
It's a decrease.
Is it
a decrease in pay?
So your family's happy with you making less money?
My family is very supportive of me and what we're doing. I wouldn't have done this. First person I talked to is my wife Mary about this because I'm not, you know, just like y'all are busy right now. I'm not seeing them, but it's a pay cut, but it's still more than what I'd be making at the DA's office, right? And so it's not going to detriment us or anything. So it's not a detriment. This is a very positive thing.
Yes.
So how many opponents do you have right now?
Right now, how I found out is I checked on the U.S. the Vote Smart thing. So right now I see Chris Buck, Robert Kasperzak, Eric Yolick, and myself. So when I filled this out, when I filled out the questionnaire, it was Robert Kasperzak and myself. And since filling out this questionnaire, Chris Buck and Mr. Yolick have put their names in.
Do you know all the candidates?
I know, yeah, I mean, I don't know them, but I've tried a case against Chris Buck before. I've met Robert Kasperzak for the first time on the campaign trail, and I've met Mr. Yolick in the past. Never had the pleasure of trying a case or having a case against him. He's actually written positive things about me in the past in the Golden Hammer, so
He writes a lot.
woo, I got to that one.
Do you do any criminal stuff right now?
I don't.
Yeah.
I mean, maybe if maybe pro bono on a Class C or something, but I don't.
Okay. So how does that grand jury assignment work? Does every judge have a Tuesday and Thursday jury, or is it like rotate once a month you get that?
It's a 90-day term, and so for that 90 days, you're in charge. Whatever district court it is in charge of the 2 grand juries.
Okay, and then the rest of the year somebody else does it? Huh?
Exactly.
Okay.
That's exactly right.
And you said you'd have to hire an admin and a coordinator. I guess that would not be somebody from some other court transferring over. You get to pick your own people?
Correct. Yep. That's exactly right. And it would be, according to Judge Bays, you want to hire the best people because that makes your job a lot easier.
Okay. You know, one thing I'm thinking of right now is that Drake Pardo case.
Yes.
Did you mention that somewhere?
I did.
And you know, a lot of courts have looked at it, and at one point, not too long ago, a court, I'm kind of thinking maybe it was the Supreme Court, issued instructions to the CPS to do a report or a study on family members that would be fit, and they gave them a deadline of, I think, a month, and, or I think he gave them 2 weeks, and a month or so later, they hadn't even started. So what does a court do when something like that happens?
When deadlines aren't being met?
Well, and especially when the state doesn't meet the deadlines for the court.
Oh, well, there's reprimands. The case can be thrown out. It can be dismissed. There's in civil law especially, it's dismissal for want of prosecution. It's called a DWOP.
Okay.
So
Even against the state?
Yes. Well, against the civil prosecutor.
Well, in your case, it would be civil prosecution.
Correct.
But in the case of that Drake Pardo, they could have dismissed that if they wanted to, the Pardo case?
Yeah, so that's the CPS court. It's not a law enforcement agency, but it is a functioning of the state. And so I think about the Drake Pardo case, if I'm not mistaken, that is where the parents fired a doctor, and that doctor who was fired complained that when the parents were seeking other medical advice, they complained to CPS saying they might treat the child potentially with a regimen of treatment that may potentially harm the child. It's one of the most wacko things I've ever heard
And the
of.
story as it's told is that the judge in that case never talked to the child,
Right.
never talked to the parents, never talked to the doctors who had actually examined the child.
That's exactly right. So, and the parents weren't even made known what the allegations were.
Yeah.
So due process was not followed at all. And we're dealing with taking away someone's children. And so it's very, very, very serious
Very
matter
much now. I think the legislator's having a special session this week on it.
for that. And so there was a stay of the order at this point, and I don't think the Supreme Court has made the final ruling yet on the writ of mandamus. That's what we're waiting on. So hope maybe that's what we're waiting on.
All right. Thanks.
Percent-wise, maybe you covered this before, how much of your experience is criminal and how much civil?
I would say 85% criminal.
Okay.
In my civil experience, I've almost doubled when I was hired. I don't want to use the word quota, but I can't think of another term right now. But when you're hired, you say this is the volume you should be seeing. I've doubled those expectations. I've settled about 130 cases in the time I've been there.
And those are civil?
Yes, sir.
Okay.
And I've traveled all over Texas. I'm admitted into every single federal district court, civil court in Texas. I practice in every single one except for the Western District yet. I haven't been out there. It's a pretty tough district, but I've had cases in Montgomery County and all over Texas.
Okay. You've answered a lot of questions that I would have here.
Ask me about jury nullification. Ask me about... oh, he's got it.
I've got it.
He's got it, okay. Dale's got it. So, let's see, 15 years experience.
You know his pants
Besides with us, 15 years. Suits you to preside over litigation matters in a Montgomery County trial court.
Oh, no, I'm in my 11th year. I'm in my 11th year.
Okay.
I may have been talking about Robert at the time.
Robert, yeah, okay.
And my point there, I think that was a question about distinguish yourself. Remember, Robert was my only opponent at the time, and I'm not knocking his experience. He's got 15 years experience in civil law, but he's self-admitted. This isn't mudslinging. This is what I've heard him tell the Republican women. He's handled complex business matters, and he's a transactional attorney. Just like there's different doctors, heart, brain, whatever. He's a transactional attorney, meaning he handled things outside of litigation, outside of a courtroom. Well, and that's what I think I was talking about that. You can't just say I have 15 years civil experience. You have to be able to tie that in with the job duties of the court. I think that's what I was saying.
Okay. How much time? Okay, let me just yield the rest of my time and I'll come back. I have some further questions.
Being a prosecutor for so many years, and I've asked we've asked this question many times, as a prosecutor, and now you're going to be a judge, how do you get unbiased?
Well, I
Because
think
you look like you're pretty emphatic and pretty dedicated. So you're a very dedicated prosecutor. How do you breach that and get unbiased?
That's a great question. So, as a prosecutor, and this isn't fluff. It's going to sound like fluff, but I promise you, whatever that means, it's not. We take an oath, and sometimes oaths, we've seen it unfortunately in today's society, that sometimes people don't, it doesn't mean anything to people. Shake someone's hand doesn't mean anything to people anymore. I took an oath as a prosecutor to seek justice, and whatever that is, we don't take an oath to put people in prison. All right. As a prosecutor, it's a lot different than being a civil attorney. Civil attorney, everyone knows what's going on. You know the case before you get to trial. Both sides know each other's witnesses. You're in depositions all day. Criminal law, the prosecutor, it's a one-way street. So I'm actually going out there looking for evidence for the defendant. All right, that's called Brady evidence. And now the Michael Morton Act passed a few years ago, and that burden was even higher. So my job was to make sure, if the government, as conservatives, we don't like big government and we distrust the government, especially if they're going to try and lock up a citizen. So the way I always approached those cases was from that point of view. I'm the government, I'm the state of Texas, and I'm alleging that this citizen should go to prison for life without parole on a sex case. I better have everything in order. I better have my T's crossed and my I's dotted. And so I would look, and there's called Brady notices on a civil case. You give them evidence that's favorable to the defendant. So I would look for that stuff. I would look for witnesses that may have been impeachable, that may have changed their story, and I'm not hiding that fact. I'm turning it over and I'm delivering it in a bow. Another thing, it's to be, and I think what you're going towards is bias. Can you be unprejudiced? Can you be well-mannered, well-reasoned? Well, I was an insurance fraud prosecutor, and now I prosecute insurance companies. All right, my career has been on both. Even though I've never been a defense attorney, the interest that I've had to look out for is for that side, and that's why a lot of the local defense attorneys in our county, they are supporting me in this race because they've seen the level of care that I've taken on these cases, and they trust my judgment to be fair. The other side is who's really been supporting me in this case.
Okay, I'm going to save the notification for the next time around, but the term in your answers has been litigation. You use that term a bunch of times. Litigation is pretty broad. Investigation, pleadings and discovery, pretrial, trial, settlement, appeal, and all of those areas. So try and get a little bit more understanding. The 75 cases that you brought up several times, does that encompass ones that have been resolved at all of those stages together, or what? And notice, how many actual trial cases have you done? How many have actually gone through the appeal process and so forth?
Yes, sir. So you're absolutely right. Litigation is very broad, and so in civil terms, you can actually litigate a criminal case. So in criminal case, I would say litigate means to try. In civil case, litigate means what you said. From the moment a petition is filed, you're in litigation. So from that stage on, remember, you file a petition, that's like your lawsuit. And then 30 days, the defense has a chance to file an answer or a counterclaim, right? And you can be on the defense at that point too, you can play both sides. But discovery is the process that lasts most of the case of litigation, all right? And so there you're doing written discovery, you're doing your interrogatories, which are written questions and answers that are verified and sworn to. You're doing requests for disclosure. You're doing designations of experts. You're going to do requests for production. That's what's known as written discovery. That takes a while. So that's part of litigation. I do that as part of my job all the time. And so these cases are in different stages of litigation. So cases can be in discovery. Also in discovery is depositions. That's a big part. Meaning you're going to be sitting down, you're going to be traveling to wherever within 50 miles of where that witness lives. They could live in New Mexico, and you're going to fly to New Mexico and depose that witness. They're going to be under oath just like they would be in front of a judge and jury in a courtroom. It's going to carry the same weight, and a court reporter's there transcribing it just like it would be in a courtroom, and it carries the same weight as testifying in a court of law. Sometimes they even video record it as well to document it. That's also part of litigation. Then there's motions practice. So when sometimes discovery is still going to be going on because you have a continuing duty to supplement discovery as you find more things out, as you discover more things. Then there's motions practice, where you can file a motion for summary judgment to exclude some of the defenses that are brought up, and they can file a motion for summary judgment to exclude some of your allegations in your petition. And that's where you're taking the facts from affidavits or from the deposition testimony, and you're applying that to the law, and you're making an argument for the judge to rule on, to say, hey, these are no good. So you're narrowing the field when it comes to trial time. And when that happens, when you're narrowing the field, it pushes the case to settle, because the judge is going to be like, okay, that great defense that this party thought they were going to have is out, or this great breach of contract claim, that's going to be out, or it's in. And so that's all litigation as far as civil law is concerned, plus trial.
My question wasn't about the process. The question was, and I'll try to be very succinct so you can give it in one word answer. What percentage of the trials, what percentage of the cases have come to trial and versus being settled pre-trial?
For all
your cases.
Oh, I would say in criminal law, I was in charge of 1,200 felony cases a year. And that's less than 1% of trial.
Okay.
Right. I'm sorry, I didn't know that's what you were asking. Yes.
Okay.
How would you describe your work ethic? We've had an issue with our courts in the past where we're paying for the courts to be open Monday through Friday, and an 8-hour day, and that hasn't been the case. Recently it has improved some, but courts were notoriously closed every Friday, and in a lot of cases on Mondays. What do you anticipate your time being in the court, in your office, available to the public as well as your employees?
Yes, sir. That's a great question, Mr. Begley. And I was one of those people sometimes on a Friday when you're trying to get a search warrant or something, and you're like, okay, what do we do, right? I think I put in there, and I'm used to working full-time. As a district court chief, when I was a prosecutor, I was in charge of every single court, every single case on the docket. I was supervising 2 attorneys below me, and I was handling the most important cases, the highest level cases. And I was on call 1 week out of the month, 24/7, all right? Right now, I work full-time as a civil litigator. I'm campaigning full-time. I'm a dad. I'm a husband. I volunteer at church at a couple charities. My answer to that question is I will get to work, and my office will be open at 7 in the morning, Monday through Friday, and we will close at 6 p.m. Monday through Friday. And that's not including my after-hour on-call shift, which I've never neglected in the past. I've always taken seriously, and I will be available. That's all I can say. I will be available. I want to work. I'm hungry. I haven't had a vacation in 2 years. I went from Friday the 13th, DA's office, to Monday the 16th at my new job. I like to work, I want to work, I would go crazy if I wasn't. And I do look at it the way that you are, looking at it that, look, this is the judge, y'all are supposed to be here, you are working for the citizens, and I actually, truly, honestly believe that. And so that's where my heart is at, a servant's heart.
So if you're working from 7 in the morning until 6 at night, 5 days a week, then you're paying overtime to your employees?
I think they're going to be salary. I would petition them to be salaried.
No employees are salary for the courts that I know of.
Okay.
And yeah.
Okay. Well, and you may be right. From talking with, I was looking at what the other, what the administrators, what the court reporters, what they were being paid. I thought it was salary, and if I'm
not across. I don't believe that they are across the board. There
Okay.
may be one or two within there, but
that's what I would try. I would try and do salary and let them know, because I would be hiring them, and I would say, this is what I expect from you.
yeah,
This is the hours of the court.
yeah, but you have to approve that through Commissioner's Court and HR, and you're not going to get by without paying overtime. We're giving them comp time.
And I know that sometimes trials, and sometimes it happens on trials where, you know, the jury's out and they're staying late and the court reporter has to be there and the staff has to be there.
Mm-hmm.
That's something I can look into and email you back on.
Because it comes back at the end of the, we had this issue just recently where at the end of the year, they needed more money, $500,000, because they had expenses that weren't covered in the budget because of things like this.
For the, okay.
Overall for the courts, for all the courts.
For the defense attorneys or for the staff?
Defense attorneys?
Okay, so that's...
No, what defense attorneys? No, it's for the staff. It's for,
Okay.
Do you remember that? $500,000 that was in the Commissioner's Court where they had to come up with the extra money because they didn't have enough. We ended up losing, the guy ended up resigning.
Nate Jensen. That was for the defense attorneys. That was for the defense attorneys. So what happened there, Mr. Bagley, this was for the court-appointed attorneys and in the misdemeanor courts.
Okay.
And so they, as we know, and this was one of the questions that y'all asked, to indigent defense. And so we have to pay them under Chapter Code of Criminal Procedure 1.051. It's the very first thing. It's, like we said, as conservatives, the government's going to level accusations against a citizen. We feel they should have representation. And the way that they, in the past, and I remember watching some of y'all's videos in the past, it was a deal where they'd keep resetting cases in the past, and they'd be getting paid, justice delayed, justice denied. Y'all have heard that a million times. They fixed that by hiring 11 attorneys for the district courts, and they handle, I think, 91 cases per attorney. And I think that adds up to about, and they get paid $76,000 a year salary. The issue in the Commissioner's Court with Nate Jensen resigning was with the misdemeanor courts, because it's not a set contract. They are paid by case. And I think what I remember happening was there was a projection, and the expenses were higher than what was expected, and they were like, remind us. Well, when the time came to pay, I think that's where the issues happened. And I think we have to pay them, so long as it's not outlandish. You know, the judges have discretion, what experts are being paid, things like that. That needs, you know, you have to balance that. But 1.051, and I think there's even the Supreme, I can't think of the name right now, but there's a Supreme Court case of the United States that says, look, people need representation. We can go after that money again if the case is disposed of and they get probation or something. We can try and recoup those fees back from the accused. But I could be missing some, but I think that the Nate Jensen resignation, I think that's what it was about.
You're right.
Okay, so you're gonna talk about nullification later, huh?
Take it,
This is y'all's show.
Hand the baton.
Okay, well, Yeah, well, let's go ahead. That's a, you know, important topic to everybody, so what's your views on jury nullification?
Y'all have heard a million answers on this, but my answer starts with jurors have to vote their conscience, whatever that is. All right, they have to be able to go home and sleep at night. And jury nullification is one of those things where, and a jury verdict is justice. I was trained, a jury verdict's justice. You go there, you leave it out in the courtroom, guilty, not guilty, liable, not liable. Jury's decision is justice. But sometimes it goes against the law, sometimes it goes against their oath to follow the law. And I'm for them voting their conscience. But if you look at the O.J. Simpson case, okay, we've all seen that evidence. It was in '95, so I was probably really young when it happened, but I've seen the documentaries and stuff. And we could probably all agree in here in this room that he murdered Nicole Brown Simpson. I think if we were on that jury, the evidence would have shown beyond a reasonable doubt. We probably all could have unanimously decided that. It's been argued that the jury, during that time, the Rodney King and some of these things, it's been argued that that jury used their jury service to nullify O.J. Simpson's guilt as a form of protest. Now, was that justice? So sometimes it was nullification.
So who were they protesting? The court?
They were protesting police brutality, what they perceived as police brutality. And so that is jury nullification. Was that justice? Sometimes it doesn't equal justice. And so it's one of those crazy things where I'm for voters, the jurors have to vote their conscience, but it doesn't always equal justice, even though a verdict is justice. It's wild. So you just gotta say they need to vote their conscience.
Are you familiar with the Sandra Merritt case?
Remind me.
She's the one who videotaped Planned Parenthood.
Oh, yes.
And Ferraris for paper
Yes.
parts. And Friday, the jury came back with a $1.5 million judgment against her.
Right,
for
for Planned Parenthood.
And the article I read said that the judge instructed them to find her guilty. Said, you will not look at this and you will find her guilty. I mean, that's just one article that I read. So it's you know, going to be appealed, I think, but that pointed out that they really didn't have
A choice.
much option. And Rodney King was the same way, you know. They told that jury, you have to show that they planned that 6 years ago to kill Rodney King or to beat him.
Yep.
So Sandra Merritt case is one that we'll see soon, I guess.
And so that's one of those things where it comes to jury instruction. And that's why even an instruction, one line in a jury charge can mean a lot. And that's why you spend a jury charge conference. It's outside the jury's presence, so that's why most people don't know about it. But that's why these little courtroom procedures are very important.
So in a case like this, or in this particular case, who can address that wrong? I mean, does it just have to go through the appeal process?
That's exactly right.
Okay.
Dale, kick it over to you.
Okay. Everybody is a conservative. I think if we set Barack Obama in your chair, he'd say, I'm a conservative.
He would say, that those jobs are dead. You can't just wave a magic wand and make those jobs appear. That's what he would say.
Anyway, so I want your definition. What are the distinguishing characteristics of a conservative? And what are the distinguishing characteristics that make you more conservative than your opponents?
It's a great question.
They all are.
Conservatism, well, it is, and that this is we need a conservative judge. We need a conservative judge now more than ever, and in this county. Y'all have access to my Facebook. You can see how what I've written about, what I've taken stands on in the past before I ever was in the judge frame of mind. To answer what a conservative is, it starts with we have our platform. I mean, I can do the whole platform thing. Right, fiscally conservative, free market, all these things, right? But for me, it's God and country, all right? It's a form of patriotism. I believe in Jesus Christ. I'm a practicing Christian. I raise my children this way. They go to a Christian school. I volunteer at church. I teach CCE classes. I teach marriage classes. I started the first of its kind in the Catholic Church called St. Matthias Guard. Since the new law passed where we can now arm parishioners, I've made it a goal. I wrote the protocols in the Catholic Church, which is hard to do. I mean, John, you'll know, to get anything done in there, it's tough. And I got my priest to sign off on it. I wrote the protocols for the security ministry, and I'm training and arming parishioners at Second Amendment law. So I'm very pro Second Amendment. I'm very textualist as far as there is meaning to the words that are in the Constitution. It's the greatest document that's ever been written, and that's why we are where we are today. I'm second generation here. My family fled Mussolini, all right? America is the greatest country. I want to wave the flag. I don't speak Italian, I speak English. My parents taught me English. They had trouble in school. I'm the second person to graduate from college in my family. My older brother Mario is a doctor and anesthesiologist. We give back to this country. We believe in service. We stand for the flag. We sing God Bless America. You can hear me. I will be the loudest one doing the pledges. I will be the loudest one singing. It's just something within me. It's how I was raised. My mom calls C-SPAN and yells at people all the time. Y'all would love her. It's something in me. It's how I was raised. It's what I believe. I did the 40 days for life. I'm out there in my suit in 100-degree weather. This is what I believe in. These are my beliefs. It's nothing. It's not a platform. It's what I live. It's what I believe in.
Thank you.
So kind of to follow along with conservatism, while you were working for the DA, what did you do to try to reduce the spending in the DA's office? Or did you find anything that was there that needed to be cut?
That's a really good question, and I keep saying that. I'm sorry, that's me thinking, taking in your question and processing.
Okay.
Sorry. And so, budgeting was not, I wasn't part of budgeting. What I did do though is I wouldn't let a case sit. And what I mean by that is when a case has come in, because when I was a district court chief, so if I'm a misdemeanor prosecutor, I'm not going to know what's going on as far as that. I didn't have a lot of supervision at that, or I wasn't supervising anything. I wasn't in charge of anything. As a district court chief, there's a couple people ahead of me. That's it. It's bureau chief, first assistant, Brett Ligon. So we're pretty high up there. So we have more administrative type things, training and things. I would take a case when it came in our the system, our paperless system. That's what's great. It made it efficient. And they gave us laptops that you can plug in and take with you. So if I'm working on call or whatever, I would review these cases when I'm home. I take my computer home and I review cases and I would put offers on the file immediately. I wouldn't let it wait. And so to reduce the spending and to reduce cases getting older, I think that's one way I reduced the budget, is because my cases, they were moving. They weren't sitting, they weren't waiting long. I wouldn't ask for, here's another way I would reduce. If we were in a punishment phase, it's a very big trial, okay? And this guy committed crimes in Florida, he committed crimes in Michigan and New York, and there are key witnesses, all right? I'm not gonna fly 7 witnesses in on the taxpayer's dime. I'm gonna choose 1 or 2, that was in my mind. Spending was in my mind when I was trying a case like that, efficiency and cost. So I wouldn't, I would love to bring everyone in, but that was something I was taking into consideration.
We've got time for one more question.
Okay. You said earlier about settling out of court, and you mentioned, I guess, that 1% went to trial and 99% were settled. So how do you settle a felony or criminal matter? Is that just like a plea bargain, or?
Yes, sir. So, and it depends on different stages, right? And so I'm going to have sometimes and/or offers when I was a prosecutor. It's totally and completely up to the defendant whether they agree. And they have an attorney to go over the issues of the case and whether or not they should or should not take it. They have counsel. But let's say it depends on the crime. So let's say it's less than a gram dope case. We call them dope cases. Methamphetamine, they're they're caught with a sugar packet that's 1 gram or less. Well, that person's probably an addict, right? I'm not going to force anyone to get help, right? But I'm going to offer it. So I would do, deferred adjudication with rehabilitative services, Alcohol Anonymous, drug intervention program, something like that, or 30 days in jail. It's 2 for 1. You want to just sit your time out for a gram or whatever. So I'm giving them the option, and so they would go in front of the judge. The judge goes over the admonitions with them because it's a felony. So there's certain rights that could be affected, as we know, voting, firearms, things like that. If they're successful or unsuccessful on community supervision, you go through all these warnings with them, and you go through a process, and they plead guilty in front of the judge. It's a form of they call it mini hearings, mini trials. And so that's how a plea would go through.
Okay. And of those cases, you said you did like 1,200 a year.
Yes.
So how many of those that were settled, just roughly, ended up in no jail time?
Oh.
Half of them, most of them?
Well, no, I mean, probably the majority, so it's like a pyramid, right? Mm-hmm. There's less murders, the more serious crimes there's just less of. The vast majority are going to be your less than a gram dope cases, right? And so, remember, jailing is going to be an issue that we have to deal with.
Yeah.
And so, are we rather going to have the top part of the pyramid in jail or the bottom part of the pyramid in jail? So, and we like rehabilitating people. That's part of it. We don't just want to throw everyone in jail. We have DWI court, drug court, mental health court, veterans court, all these courts going on. And so you want to give them the option. So I would say of the largest part of the pyramid, at least we're offered no jail time, no prison time.
Okay.
All right. So while we wrap it up, take what you need up to 5 minutes to close, and then we'll wrap.
I don't think I need to do closing. I think y'all I'm sure have looked at my Facebook, you've looked at my website, you looked at the press releases. I take this job seriously. I think the Tea Party's important. I think y'all are important. I think what you do is important. And I'm to answer Bob's question again, John, and this is not a knock, but we've had to reschedule this a couple times because of life, right? Life happens. And thank you, right before y'all's vacation, you're doing this. But I'm campaigning, I'm working, my wife doesn't see me right now. Okay? I take her out on a date to go see the new Dr. Sleep movie and to Joe's Italian food. It was a hot, awesome Friday night date. John calls me in the middle of the movie. I get back to him. Immediately.
Worst nightmare, right?
Well, no, immediately. Because to me, y'all are vetting us. I'm used to being on call. I've lived this life. You want to be able to put a judge on there that's going to answer the call. And so you could move this 1,000,000 times. The camera could fail 10 times. I'm your guy to, okay, stuff happens, I'll be there the next time. And I really want y'all to know that.
Appreciate that. All right. Well, thank you very much.
Thank you.
Thanks for going through the process.
Happy to do it.